What you know, alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Monday, January 27th. Hope you guys are having a good day so far. We're going to jump into the motion to suppress evidence hearing in the Kouri Richins case. Before we do, one big thing happened. Prosecutors conceded that investigators seized an orange notebook from Kouri Richins' home illegally, agreeing that investigators didn't initially have a warrant to take the notebook that they found on the May 8th, 2023 execution of the search warrant at the Richins' home. The defense says the officers opened the notebook, read its contents, and then sought an amended warrant with authority to seize the notebook. The defense says the contents are protected by physician-patient privilege because they were intended for Kouri's therapist. The defense wants the judge to toss it out. And they say by taking it, investigators found information they might not have otherwise known. If the judge agrees, it could open the door to toss out other evidence. The state is expected to argue that deputies would have eventually found the notebook or any other evidence that it pointed them towards lawfully. If they are successful in their argument, it could get the evidence back. The judge didn't rule, and there will be other hearings about the issue in the next few weeks. If any of those briefings come down, we'll go over those, and I'll keep an eye out. It's a good reminder, if you're not subscribed on YouTube, go ahead and click subscribe and hit that little bell notification if you want updates of when I post new content. Sometimes I do a YouTube short, so if you're just listening to the audio version, you might not catch those. One other thing to mention before we dive into testimony, there was some off-camera testimony by Detective Eric Maynard, but I do have notes from inside the courtroom from my dear friend Laura, and I'll include his testimony in the second episode about this hearing. Just a reminder, Kouri is accused of killing her husband, Eric, by poisoning him with fentanyl. The first witness up was Detective Woody. She was the lead detective on the case with Summit County Sheriff's Office. She's currently a K-9 deputy. On April 13th, 2022 at 10 a.m., they were preparing to execute a search warrant at the Richins' home. She got word that Detective Maynard had stopped Kouri near her home. And when she got to the scene, she saw Kouri in the front passenger seat of the police car. Kouri was not handcuffed and she was not placed under arrest. The witness said Kouri sounded like she was crying, but she never saw tears. She did make an audio recording of the interaction, and the state has her read from the transcript. She asks Kouri if she wants to come with her to get her cell phone from her car, which they did. Kouri reached into the car and gave the phone to Detective Woody. The detective asked Kouri if she wanted to take the case off the phone because there was a pouch on the back that held cards. Kouri did not remove that and gave the detective the phone. Reading from the transcript, the witness said, then he, meaning Detective Maynard, will follow you back and you can do that. That meaning she needed to get some numbers off that phone. After the audio recording, the witness goes to a woman named Becky's house. Becky was an employee of Eric's company and had some electronics that the witness wanted to recover. Now, Becky's house is right off the street where Detective Maynard had stopped Kouri, so the witness just walked there. The next time she interacted with Kouri was at the residence. They asked Kouri if she would provide the code to the safe or open the safe, and Kouri said she would. They were walking back and forth to the safe, and according to the witness, Kouri is following her and asking about the warrant. What are they looking for? What have they found? The witness really didn't want to talk to Kouri. She wanted to serve the warrant and finish up there. The state was finished with their direct, and up next was Kathy Nestor for the defense. Regarding the search of the home, the witness was the one that asked the judge for the search warrant, and they had gotten two. The first warrant was obtained 2 days before, which authorized a search for fentanyl and any mailing or tracking instruments that would indicate purchasing. That second warrant was to search the home and Kouri's person for electronics. The defense asked the witness, did you seek authority to search cars? No. The witness went back in the process of serving this warrant and then asked for a third search warrant to search the cars. At the time you got the phone out of her car, you didn't have a warrant to search her car. The witness says she personally did not get the phone out of Kouri's car. The defense says you knew you needed another warrant because you went and got one, and the witness says yes. The defense has the witness look at the transcript of that audio recording and says at the stop, Kouri asks you what's going on, and you said that this search warrant was to make sure there's nothing dangerous for her or the children due to the fact that the cause of death for Eric was fentanyl. You guys had a conversation about how just a tiny bit of fentanyl can be dangerous, and the witness agrees. They turn to another page in the transcript, and the witness asks Kouri, do you have a phone with you while she's sitting in the car being detained? And the witness says yes. Kouri said the phone was in her car and not on her person. The detective asked Kouri if she wants to come with her and grab the phone. Did you read her Miranda rights, or did you tell her she had an option of whether or not she wanted to cooperate? The witness doesn't believe she said anything like that. The witness was wearing a shirt identifying her as law enforcement, but her jacket covered the logo. The witness had asked Kouri prior to her being detained if she would be interviewed by police, and the witness knew Kouri had an attorney. The detective talked to Kouri's attorney about her being interviewed, but the witness did not advise Kouri at the stop she had a right to call her attorney. The defense asks if the witness asked Kouri to hand her the phone. The defense reads from the transcript and says, you ask if she wants to take it out of the case or not, and then you take the phone from her. You didn't even ask, you just took it. The witness says, no, I asked if she wanted the case and she handed it to me. But the defense has the witness say she did not tell Kouri she did not have to give her the phone. After that, the witness told Kouri that Detective Maynard would follow her back to the house. She's asked when she gave the phone to Detective Maynard, and the witness said probably when we were walking back towards the car. Once the witness was back at the residence, at some point she took the phone back from Detective Maynard. She doesn't know if Kouri gave him the passcode to the phone or not, but the witness said the phone would have been put into evidence at the station. Back to talking about Kouri giving them access to the safe. The witness said she asked Kouri for the code so that they would not have to damage the safe to open it. The defense asked if the witness informed Kouri that she had a right to refuse, and the witness said no. At this point, Kouri had not had her Miranda rights read to her. Kouri was in a car when the detective asked her to open the safe. And the defense says while you were walking around and Kouri was following you, she asked if you had found anything dangerous like fentanyl that would have been a danger to her or her sons, and the witness says yes. The defense asked the witness when she was removed from the case, and she said a little while after I got the dog, meaning the canine dog. The defense asked if she knew anybody in the Richins family before. The witness said no. A lot of Richins live in the area, but she doesn't think she knew anybody associated with this case specifically. One thing I do want to make clear, as far as I understand, Detective Woody was not demoted. She chose to go back and work with canines. Moving on, the defense asks if the witness heard from Kouri's lawyer after the search. The witness doesn't remember. The state interrupts here and says anything that happened after the search is irrelevant to the pending motion. But the defense says later today, I'm going to question Detective O'Driscoll about his interview with Kouri when she was uncounseled, and I'm just laying the foundation. She shows the judge a stack of papers and said that her lawyer asserted Sixth Amendment rights and told them not to speak with their client again. The state gets up and said, we're going to have to put a lot of objections on the record here. The judge asks for context, and the state says that the defense attorney just said she's making a Sixth Amendment challenge later on to an interview that was conducted with Kouri on April 14th of 2022. At that point, the legal proceedings had not started, which means the Sixth Amendment hadn't attached yet. The state said they don't object to these emails coming in, but there's also metadata that attaches to the emails that to the extent the metadata becomes relevant. It's in discovery. So the judge asks to see those emails. The defense asked the witness if these emails are what were forwarded to her, informing her that Kouri's attorney did not want Kouri spoken to again outside the presence of counsel. And the witness says that looks right. The defense asked what she did with the emails, and the witness probably showed them to her boss, and she would have put those in the case file. When she left the case, she left all of her materials to Detective O'Driscoll. The defense asks if when Kouri was detained, did she show Kouri a copy of the search warrant? The witness says not at the car, but she does know Kouri did have a copy at the house. The defense asks why she quit the case other than wanting to train her dog. The witness said, I just didn't have enough time to train the dog. So that was it for Detective Woody. The next witness up, Chelsea Gibson, lead crime scene investigator for Summit County Sheriff's Office. The state gets up. Her duties include phone extractions, and she worked with Kouri's phone that was taken into evidence. It was an iPhone 12, and they used the Celebrite software to extract the data. That was extracted on September 27th of 2024, so just last year. The defense is up. The sheriff's office didn't have the capability to crack the phone and download it without a code in December of 2022. So it was sent to the Regional Computer Forensics Lab on May 22nd of 2022, and that was returned back to the sheriff's office in July of 2022. They did have a passcode on the property tag of the device. When the witness received it, she then gave that to the lab. The defense asks if she sees the phone on the evidence seized list from the day of the search warrant, and the witness does not. The phone is listed on the witness's spreadsheet of evidence seized, and while most other evidence has a location of where items were seized from, the phone did not. There was also no location listed for pills as well as scene photos. The state is up, and they ask about there being different case numbers on the spreadsheet and ask the witness if this was simply a tool for her to use, and the witness says yes. They ask about the property seizure form and points out this form is only for the home. If anything was seized off property, it would not be on that form, and the witness says correct. He asks if the lab was able to extract the phone, and they were. The lab gave the sheriff's office a drive with the contents, but at the time, they did not have the capabilities to look at that extraction until December of 2022. The next witness is the current lead investigator in the case, Detective O'Driscoll. He wanted to inform Kouri that there was a change in the lead investigator in her case, and there had also been a change in the sergeant over the detectives. So he went to meet with Kouri at her house with a Sergeant Hoffmeyer on April 14th of 2023. He recorded that interaction with an audio recorder and then asked Kouri if he could record with body camera. He wasn't in uniform and there was not a mount, so he sat that body camera on the armrest. He verifies it makes a noise every few minutes, and also there is a red light when it's recording. They go back to that transcript where he's at the doorstep and Kouri invites him in. When they go inside, they all sit down, and Kouri's mom, Lisa Darden, comes in the room and sits as well. The witness said Kouri was cheerful and happy to be talking with them. He didn't see her cry during the conversation. They move on to an email Kouri sent him and Sergeant Hoffmeyer, where she was providing additional information about the things they had spoken about in her home. On cross, the defense asked if he had the case file after being assigned the case, and he did. She says, I'm certain you didn't go into the home of the primary suspect unprepared to interview her. The witness said not entirely unprepared, but the intent was not solely to get an interview. It was to introduce ourselves with the change that had happened. The defense asked how long the introduction would have taken, and the witness said not long. The defense points out he and his partner were there for 3 hours. And on April 13th, 2023, the day before he visited Kouri at her house, he had obtained a search warrant for Kouri's phone and also a computer. The affidavit for the search warrant was 2 pages and single-spaced. In the affidavit, there were things Kouri had told the previous detective regarding toxicology reports, and he referenced an interview that was done by Detective Woody with a friend of Kouri's whose initials are CB. And the defense asked Detective Driscoll, you suspected she had deleted messages? And he said yes. The defense starts asking him about being able to write the search warrant affidavit with talking to Detective Woody and the information he had about the interview with CB, which came from a conversation with Detective Woody and Sergeant Davis, not from the case notes. He said he didn't look at all the case notes before he did the affidavit for the search warrant. So the defense asks if he made it extremely clear in the affidavit that Kouri was the primary suspect. He said no, he didn't have definitive information that she was a suspect at that point. The defense says, but you wanted to look at her phone to see if she had tried to obtain fentanyl on her phone? He said yes. With the limited information he had, the most important fact to him was that Eric died by a fentanyl overdose. And his biggest question was how fentanyl got in his system. And he had three opinions on that. The first would have been accidental, the second, self-harm, and the third, homicide. He said in an effort to be thorough, he was investigating all of those possibilities. The defense asked if 1 year after Eric's death, they still had no idea which of the three it was, and the witness said that's correct. The defense says you show up to have this friendly interaction with Kouri. You spend a month reviewing the information in the case, and the witness says no, he didn't. He still had a full caseload besides this case. He reviewed what he could with the time he had. But the defense says you had enough to do this affidavit, and the witness said he would talk to the previous case investigator, but he did not have a full debrief of the case. He also had not looked at the material that was taken off of Kouri's phone. The defense says you show up at her house. You don't tell Kouri you just had gotten the search warrant for her private information, but what you tell her is you guys all coach soccer together. The state tells the judge they renew their objection. What he told her is documented in the audio recording. The judge asks the defense if she's trying to lay foundation, jog his recollection, or can we just move on? And the defense says all three. She asked the witness, you had ties to the community through soccer coaching and maybe she knew your wife or something? And he said yes. But you didn't tell her you were investigating her for homicide at any point in those 3 hours? And he said no. You also didn't tell her you had a hidden recorder on your person when you arrived to her house. The witness said no. The intention was not necessarily to hide it. The audio-only recorder was brought in case of a failure of equipment. It was in his pocket. It wasn't an intent to hide that he was recording her. She asked if he had a weapon on his person when he was at the home, and he thinks he did, and Sergeant Hoffmeyer probably did as well. She asked if the other detective had a hidden recorder on his person. The witness said their memories have been a bit confused on this point. The witness thought Hoffmeyer had the recorder, but after listening to it, Hoffmeyer was far away from the microphone, and he thinks the recorder was on his person, and that, along with the body cam, were the only two recording devices. The defense says you intended to go there and ask her questions directly about what happened with Eric's death, didn't you? And the witness says yes, after she invited us in and consented to be interviewed. He says he did not read her Miranda rights, and he did not know at that point she had an attorney. So the defense refers the witness to the transcript and said, you'd only been there a few minutes, and read what Kouri said to you. And he does. It says, my attorney has been pushing to, we just wanted her off the case, meaning Detective Woody. We're not getting anything accomplished. The defense says minutes into your meeting with her, she advised you she had an attorney, and the witness says yes. Were you going to elicit information from her that could be used against her? The witness said, I didn't know what information she would provide. I just wanted to know the facts surrounding the night of his death. The defense says if she had said, I killed my husband, would you have used that against her? And the witness says likely. The defense says, but you didn't read her Miranda rights. No. Did you tell her she did not have to meet with you? No. You knew she had an attorney and you were looking for information about her involvement in Eric's death, and you didn't read her Miranda rights? The witness says correct. He's asked if prior to applying for the search warrant for the iPhone in April of 2022 and prior to meeting Kouri, did he review reports about the seizure of the iPhone in April? No. The defense asks if he remembers reviewing correspondence from Kouri's attorney that was in Detective Woody's case file about not discussing the case with her without an attorney present, Or do you remember discussing that with Detective Woody? There was an objection by the state here, and the defense just rephrased the question. So prior going to interview the key suspect in a murder investigation, you didn't take 1 minute to check to see if she had an attorney after a year? No. Again, the state objects to the line of questioning based on the Sixth Amendment and that the Sixth Amendment hasn't attached yet. And the judge says, so you say, but we're going to have to get into some briefings about whether this proceeding has reached a critical stage under case law and whether it begun to focus on a particular suspect or other critical stage. Let's just get the facts in. Just a little refresher of what the Sixth Amendment is. It protects the rights of criminal defendants. It guarantees the right to a fair trial, including the right to an attorney, an impartial jury, and the right to know the charges against you. The state wants to finish putting this on the record and then move to the Fifth Amendment. He says Idaho case law in the Padaki case says it attaches at arraignment, and I think it's clear there's no Sixth Amendment. It had not attached at this point in the narrative. For the Fifth Amendment, it attaches where there is a custodial interrogation. The judge says truth. The state goes on and says that Utah's Perea case, citing to McNeil versus Wisconsin of the Supreme Court, says one cannot anticipatorily invoke a Fifth Amendment. You need custody before you can invoke the Fifth Amendment, and all this business about whether the defendant was represented, whether Detective O'Driscoll knew she was represented or otherwise is immaterial. The judge says to the Fifth and not necessarily to the Sixth. We will see if your case law is correct, but I understand your point regarding the Fifth. The judge says, I think the Fifth Amendment issue is why they keep asking if he had a gun on and a show of force, free to leave, Miranda rights read. The state agrees and says one day they will make that argument. The state goes on to say they feel certain they can seat a fair and impartial jury in Summit County, but they worry the more information, and in this instance, the more false information that is put into the potential jury pool will make it more difficult and will cause jury selection to take longer. The judge says, I've shared this concern in this case since the initial detention hearing, given the level of media attention. But the reason I don't think that cuts one way or the other with respect to Summit County versus Salt Lake versus Washington County is because the outlets that are covering this, 95% are national outlets or new media outlets on YouTube that don't respect any county boundaries. And while I think the concern is valid, it applies to every potential jury pool. The state agrees and said they'll argue that one day in the future. But the reason he brings this up now is the publication of false information through the course of these moving papers and this examination. It's unhelpful to quickly find a fair and impartial jury, whether it's in Summit County, Salt Lake County, or wherever. The judge told the state he appreciates the concern, but doesn't think we're even approaching the point of no return, but says he will stay vigilant. The defense wants to point out that all of these materials come from the state. The judge tells the defense to move on. The defense says you got an arrest warrant for her a couple of weeks after this start from scratch interview with her. Yes. In the space of your interview with her on April 14th, 2023, and her arrest on May 8th, 2023, which is about 2.5 weeks, you decided it was a homicide and she was the one who did it, and that's 3 weeks. You apply for a warrant for her house on May 3rd, and in that period of time when you had this interview with her and the time you issued the warrant for her arrest and the search of her house, did you ever investigate any other potential suspects? He says, to an extent, yes. The defense says she assumes he has reports on that, and he says yes. She says, we're not going to get into all that. She asks again when he got the warrant to search Kouri's home, and he said May 3rd of 2023. She points out again, less than 3 weeks after you interviewed her. Yes. You asked to search for 2 things in the house, counterfeit pills and copper cups, and that warrant was issued. Yes. And the warrant gave you the authority to search her home on the day of her arrest? He agrees. The defense says on the day of her arrest, she wasn't home. She was in Salt Lake, and you were present for her arrest? Yes. Did she have a phone on her person at the time? The witness says, yes, it was in her hands. The defense asked if he pulled Kouri out of the car, and he said no. She was exiting a business, and he approached her while she was walking out. The defense apologizes and asks what he told her to do with the phone, and he said nothing. The state objects, saying this seizure isn't the subject of any of the motions. They go back and forth with the judge, and in the end, the defense attorney says she got confused. It's a whole other issue. She moves on and says at the time of Kouri's arrest, there's officers searching her house, and you get a call from one of the officers on scene who advises you they found something in the search that wasn't within the permission of the warrant. The witness doesn't remember. The state says they think this is about the orange notebook, which is issue 4 in the defense motion to suppress statements and evidence. He reminds the judge the state has conceded the state seized that notebook on May 8th, 2023, beyond the scope of the warrant that the defense is addressing. The judge says the state will be arguing on inevitable discovery. That goes back to what we talked about at the beginning of the episode with Kouri Richins' brother-in-law taking the stand about the fact that after that search warrant was executed and investigators were done, the investigator for the civil cases for the Eric Richins Trust were going in right after they got finished and inevitably would have found this notebook anyway. The state said this examination is nothing more than to prove a fact that the state has conceded. The judge asks if there's anything else the witness needs to testify to regarding that orange notebook. The defense says yes. So the judge asks the defense to proffer for him what else she needs. She says all the steps that are made and the order of the steps that are made about the search file into our entire fruit of the poisonous tree argument. I need to lay the foundation if I ever need it on appeal. I need to make clear the steps they took with the orange notebook. The judge says it's a problem now that they need to invoke some kind of exception to fix. Is it the steps after the orange notebook that would be relevant to the fruit of the poisonous tree? The defense says that's what I'm asking him about now. And she begins talking to the witness again, saying, you get this call, they find a notebook in her house. The state says, I don't know that we're fully clear on this issue. The judge asks if she's preserving the ability to argue that there is a gap in time when the notebook was found to when it inevitably would have been found. And within that gap of time, investigators learned some things that is the fruit of the poisonous tree. And the defense says yes. The state says on May 8th, there was a second warrant that was written to search the home for that notebook. And again, they concede with the second warrant, there were other collateral issues that don't touch on this that were invalid because it relied on information discovered in the notebook pursuant to a search beyond the original warrant. The state's inevitable discovery argument is about warrants that occurred way after the May 8th date. All of the information those warrants relied on are in the affidavit of probable cause for the warrants. At this point, the judge asked to pause, and he thinks the discussion would be more detailed and fruitful if both sides weren't worried about seeding the public record with a bunch of stuff you don't want jurors to know about. He said that's a sufficient basis to close the proceedings briefly and have a more detailed discussion about the topic. At that point, he asked the public to step out and for the stream to be muted. And that is where we're going to leave off here on episode 1. I think we're going to see some more big briefings here soon, more hearings about this orange notebook. And I mean, it could go either way at this point. Does the judge remove some of the evidence due to it being the fruit of a poisonous tree? Or is the state successful in saying eventually we would have found this notebook and pretty soon thereafter? Episode 2, we will go through some other witness testimony. They also have some video of the cell search in the Wag the Dog letter discovery. Lots to unpack, and we will do just that. Hope you guys have a good rest of your afternoon, and we will see you soon.